Hello and welcome to this session in which we will keep discussing the elements of the contract. There are three elements to have an enforceable legal contract, and the three elements are offer and acceptance, someone who makes an offer called the offeror, and someone who accepts the offeree, and they have to have a mutual assent, mutual agreement. There should be an exchange of value, consideration between the two parties. And the third element should be no defense, no reason for the court not to enforce this contract. In the prior session, we covered element 1 and element 2. In this and the next few sessions, we are going to discuss no defense. Simply put, for a contract to be enforceable, there should be no defense in the court of law. Simply put, if you take it to the court of law, no reason for the court of law not to enforce it. So, defenses, if there is any defense, can render the contract either void or voidable. So first thing we need to learn about is what is void, what is voidable. Then we would look at events or things that's going to make the contract not enforceable. Not enforceable means it's not an enforceable contract. It lacks one of them. Therefore, it's not an enforceable contract. Let's go ahead and get started by looking at void, making sure we know the difference between void and voidable. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
Void versus voidable. A void contract is inherently invalid from the start. Right from the get-go, the court doesn't think a contract should exist and they cannot legally enforce this contract. They will treat it as the contract has never existed. So, reasons for contract being void included illegal content or lack an essential element like mutual consent. So if we say, because of that, the contract is void, it means there is no contract. X on the contract, neither there is no offeror, no offeree, there is no contract. If the court thinks the contract is a voidable contract, well, is initially valid, there is a contract, but can be annulled at the discretion of one party due to the issue like misrepresentation, coercion, or incapacity. Well, what does that mean? It means the contract can be terminated by the party that was not at fault. So there's going to be one party at fault, one party not at fault. If the party not at fault, the party that was damaged as a result of this misrepresentation, coercion, or incapacity, they can get out of the contract. So it remains enforceable until the affected party chooses to void it. So one party can go ahead, proceed with the contract, or they can say, you know what, I'm not interested, therefore it becomes technically void. But voidable means the party that's injured can still carry on if they choose to. Well, one of the things that the court look at to see if this contract should be void or voidable is the fraud. Was one party defrauded? Well, what are the elements of fraud? Well, elements of fraud, there are 5 elements. One of them is misrepresentation of fact. The defrauding party must have misrepresented a fact, the party that's committing the fraud, that's significant to the contract terms. For example, they told you the car was never in an accident, but the car was indeed in an accident. That's a fact. This cannot be a mere opinion. So they're not giving you an opinion, they're giving you a statement of a fact, and that's a material statement of a fact. So simply put, if you know the car was into an accident, well, you are not going to buy it. It's not about the value of the car, because the statement of a value is an opinion, unless the statement of a value is coming from an expert, like an appraiser. You ask an appraiser to appraise a home, they gave you the wrong value, and you relied on that. Yes, the appraiser is giving you the value, but the appraiser is an expert. If they misrepresented a fact, then that's one element of the fraud. The other element of the fraud is you have to have what we call sinister or intent to deceive. So what they did, they lied to you. It's not only they lied to you by mistake or error, they did not give you the right information because they did not know any better. They knew better. The fraud was intentional. The false statement must be made with sinister. So they did not only misrepresent something, they did it on purpose. What's the purpose? To deceive you, to mislead you. This intentional can be direct or indirect. If misrepresentation is made with a reckless disregard for the truth, it still qualifies. And the last scenario, which is, disregard to the truth, is often referred to as constructive fraud or gross negligence. That's the second element of the fraud. So you have to represent a material fact, and your intention is to deceive. That's not enough. We have a third element. And intent to induce reliance. So you're making the statement to convince the other party to make the purchase. So the defrauding party aims in making a false statement must be to get the victim to rely on this misinformation. And you have to show that you did rely on the information. You made a reasonable reliance. The victim must have actually relied on the misrepresentation, the value of the house. And the reliance should be considered reasonable under the circumstances. You cannot just say, well, I relied. You have to kind of show that you relied. This means the victim believed the false statement and acted based on that belief. So you have to show that. And you also have to prove damages. To claim fraud, the victim must have suffered some form of a loss due to the fraudulent act. So the victim of the fraud has the right to either rescind, cancel, get out of the contract, or sue for monetary damages. I was damaged because of the fraud. I'm going to sue you. But you cannot pursue both remedies. So you need to be familiar with the 5 elements of the fraud. You're going to see them if you're studying for the CPA exam when it comes to securities law. So we look over them again. So make sure you know them. Now we have to differentiate between fraud in the execution and fraud in the inducement. The fraud in contract law often categorized based on the defrauded party's awareness of entering into a contract. So were you aware or not? This leads to 2 types of fraud. Fraud in the execution of the contract and fraud in the inducement. So we need to know the difference. We're going to start with fraud in execution. This occurs when a person is misled into signing a document without knowing it's a contract. So you executed a contract without knowing it's a contract. For example, if we consider this scenario with a celebrity, they believe they are signing the fan's autograph book, but in reality, what they did under that picture, there is a contract. They sign a contract. The key issue here is that the deceived party does not realize that they are entering into a contract. It's fraud in the execution of the contract, leading to a complete lack of mutual consent. Remember, one of the elements of the contract is there is a mutual consent, a mutual assent, what we call meetings of the mind. Here, there's no meetings of the mind. The celebrity was signing the picture, an autograph. They end up signing a contract. In those circumstances, the contract is void. What's void? Just tear it apart. It doesn't exist. This means it's treated as if it never legally existed because of the fundamental basis of the agreement was absence. Now, fraud in the inducement, this type of fraud happens when the defrauded party knows that they are entering into a contract, but is deceived about the contract term or other significant aspect. What could be an example of it? A person being misled about the features or quality of a product they are purchasing. While the party knows that they are signing a contract, their understanding that they are agreeing to is fundamentally flawed due to its misrepresentation. So you're getting the wrong picture. In these circumstances, the contract is voidable, not void. What's voidable means? It means you can get out of it if you choose to. This means that the defrauded party has the choice to either affirm the contract or continue with it or reject it. You can, whatever you want to do. The court gives you that option. If they choose to reject or rescind the contract, it's treated as invalid from the start and the contract is gone. Let's take a look at a simple example. Consider Bob, who's looking to buy a used car. The seller, Chris, advertises the car as having brand new engine. That's a fact, and only 10,000 miles on the odometers. Those are facts. If it has a new engine, well, it have it or it doesn't have, and the 10,000 miles on the odometer of the car, is a fact. Well, trusting this information, Bob decides to purchase the car. However, after the sale, Bob discovered that the engine is not new and the odometer reading was altered. The car actually has 100,000 miles. Well, we have misrepresentation of facts with the intent to do what? To make you buy the car. So Bob bought the car under the wrong facts. Here, Bob knew he was entering into a contract to buy the car, but his decision was based on material misrepresentation about the car's condition. And this is a classic case for fraud in the inducement. So what can Bob do? They can choose to void the contract due to the misrepresentation. As the contract becomes voidable. So fraud is one of these things that you can makes the contract void or voidable. How about innocent misrepresentation? What's innocent misrepresentation? Well, is a concept that closely resembles fraud, except that you are not trying to deceive. There is the absence of sinister. Remember, one of the elements of fraud is sinister, the intent to deceive. You don't plan to deceive the individual. You just made a mistake, an honest mistake. So you have a misrepresentation of a material fact, but you made this, in quote, innocently. Innocent misrepresentation involves a false statement about a significant fact. But you're not trying to deceive. And this happens. You made this innocently. The critical distinction is innocent misrepresentation. The false statement, you have no plan to defraud someone. The party making the statement genuinely believe it's to be true at that time. So in this situation, the contract is voidable. As a result of this misrepresentation, the contract becomes voidable at the discretion of the party who was misled. And this means the deceived party can choose to either continue or rescind it. Treated it as it never exists, it becomes void. Let's take a look at an example. Sarah is selling her house, and during the process, she informs potential buyers that the house roof is only 5 years old and is in excellent condition. Well, and Sarah genuinely believes this is the case, as she recalls having the roof replaced about 5 years ago. So based on this information, John decides to purchase the house. Well, after the purchase, John discovered that the roof is actually 15 years old and requires significant repair. It turns out that Sarah mistakenly remembered the age of the roof. Now, how would we differentiate between the two? That becomes a matter that the court would resolve, but here we're assuming that Sarah made this misrepresentation innocently. She had not intended to deceive John, but was simply incorrect. This is an innocent misrepresentation. This is the example of it. So Sarah made a false statement regarding a material fact without any intent to deceive John. She genuinely believed her statement to be true at that time. So that's another way to make the contract voidable, not enforceable. Duress. What is duress? This duress refers to a party being forced into a contract under a threat, which is they're not going under this contract under free will. Simply put, someone putting a gun in your head. That's what a duress is. If the threat is a physical form, sign or harm you, the contract is void. It means no legal validity. The court says forget it. It's void. If the threat involves economic or social coercion, for example, sign or you are fired, or sign or we will divorce, the contract is voidable. In other words, you can, whatever you want to do, if you want to keep going, you can. If not, you can get out. If they are coerced party, can choose to void it if they choose to void it. However, simply exploiting someone's economic situation in negotiation is not considered duress. If someone in a bad economic situation and you did not put them there, that's not your problem. That, this becomes basically negotiation between you and that party that's under economic duress, but you did not put them under that economic duress. So that's not duress that we are referring to here. An example would be a physical duress. Elise is threatened with harm by Bob unless she signs a contract to give him her car. The contract is void. Economic duress, well, Dave is told by his employer, sign a new contract with less benefit or lose your job. Let's talk about undue influence, which I believe it's a form of duress. Undue influence happens when one party has the ability to do what? To overpower the other party. Why? Because they have a position of power, a position of trust or confidence over the other party. And this typically involved a party that's dominant. Dominant, it means dominant in a sense they can exploit their influence. They can use their influence to convince someone to do something that does not reflect their free will, because the other party is considered, in quote, weaker. What could be a relationship? Undue influences arises when someone is in a trusted role, like spouse, guardian, attorney under client, CPA, religious figures. Those individuals, usually they have power over other party because of their position, of their capacity, of their knowledge, of their professional status. They can exploit their position to capitalize on other people's vulnerability. Simply put, what they're doing is they're violating their trust or confidence. Because, you have a relationship with your attorney, there must be a trust there, you trust them, they're looking after your best interest. Same thing with your CPA, if you have a guardian, your spouse, religious figures, so on and so forth. When undue influence is proven, the contract becomes voidable, meaning that the influenced party can choose to either affirm it or rescind it. And let's take a look at this example. Emma, an elderly woman dependent on her caretaker, Let's take a look at this example. Emma, an elderly woman dependent on her caretaker John. So what John did is persuade her to change her will, in his favor. So John uses his position of trust to influence her decision. So since she's relying on him, and she's vulnerable, she's old, she's sick, he takes care of her, her decision is more due to John's pressure rather than her own free will. So this scenario of undue influence could lead to the annulment of the will change. Basically, you can cancel it. It doesn't work, as Emma's ability to make independent decision was compromised. And this happens a lot between families where they would say, one individual convinced the parents to change their will into their favor. If you watch movies or show, that's a very common story. This is an example of undue influence. What could happen under some circumstances? We could have a mutual mistake. Mutual means a mistake in the contract as to the quality of the item or to its existence. So what's a mutual mistake? This is a situation where both parties have shared misunderstanding about the fundamental fact that's crucial to the contract. When there's a mistake, when this mistake exists, it impacts one or both parties, it can render the contract voidable, allowing the affected party to do what? Get out of the contract. The contract is not enforceable. Now, it's important to note here that mistakes regarding the value of the subject, how much it's worth, are usually not considered an error, not considered a mistake, because that's a subjective thing. How much you think something is worth is something totally subjective. Let's take a look at an example to kind of illustrate what do we mean by mistakes. Let's start with an example of mutual mistake as the quality. Jordan and Taylor agree on a contract where Jordan will buy what they believe is a rare vintage wine from Taylor for $500, and both parties believe that the wine is authentic and valuable. Then what they find out later, that the wine is actually cheap, recent production, and not vintage. Well, they both made a mistake. John can choose to do what? Get out of the contract, void the contract, and move on. Both parties were mistaken. Let's assume if we have a mutual mistake as to existence. Scenario: Chris agreed to buy a unique painting from Pat for $10,000. Both believe that the painting exists and it's in Pat's possession because Pat is selling it. Well, unknown to them, the painting has been stolen a week before the agreement was made. Well, the outcome is the contract becomes void because the subject matter, the painting, don't exist anymore, and both parties were mistaken as to a critical fact, and that's the existence of the painting. We could also have unilateral mistake. Unilateral is the mistake from one party. Well, when one party in a contract has a misunderstanding about a significant fact related to the agreement. Generally, a unilateral mistake does not offer ground for a void contract, but there's some notable exception. If the other party is aware or reasonably should be aware of the mistake, then the mistaken party may have a defense. Let's take a look at two examples that illustrate this concept. So here we're going to look at an example where the unilateral mistake, not a defense. Lisa buys a commercial grade refrigerator for her restaurant in a hot climate. She operates in a hot climate environment, assuming it will function well in high temperature. She doesn't tell Tom, the vendor, about her specific needs. She just bought it. Well, the fridge malfunctioned at high temperature, but Lisa never shared this requirement with Tom. Her unilateral mistake about the fridge performance doesn't give her ground to void the contract because she did not tell Tom about her situation. And we're going to assume that Tom was not aware of her particular needs, so he would not have known to advise her differently. Under those circumstances, Lisa's unilateral mistake does not provide a defense for voiding the contract. Let's take a look at another example. Maggie is looking for a contractor to renovate her house, and she received several bids. One contractor, Bob, mistakenly submitted a bid of $2,000, way lower than the other bids, which were around $10,000. So he submitted the bid, and it's 20% of the other bids. Now, Bob's bid is an obvious error. It's way less than the market. Like anyone would know, the work that Maggie needs is approximately around between 8 to 12,000. This person is bidding 2,000. Okay? Since Maggie can reasonably be expected to recognize the mistake, then Bob may be able to void the contract on the grounds of unilateral mistake. Again, you're saying, how is these issues resolved in the real world? Well, you might have to the court, or they will agree and say, oh yeah, this does not make any sense, let's void it. Or sometimes you might have to the court. And most likely, let's assume they go to the court, the judge will see, yes, this is obviously a mistake. Maybe Bob did not really understood Maggie's requirement and, will void it. Let's take a look at this multiple choice question from farhatlectures.com. When can a unilateral mistake make a contract voidable? So someone made a mistake, and because of that, the contract becomes voidable. It means the person that made the mistake can get out of it. Okay, let's take a look at the answer choices. The mistake is related to the value of the contract. Well, the value of the contract is something that's subjective. If either party make a mistake about the value, it doesn't make the contract voidable. Therefore, A is out. The mistake was due to a typographical error that both parties overlooked. Well, would this be a unilateral mistake? Well, both parties overlooked. This is a mutual oversight that does not typically void the contract unless it's about a material fact. I would say D is not the answer. The mistaking party did not read the contract thoroughly. Well, failing to read the contract, that's negligence. You should read the contract, but does not render the contract voidable. If you did not read it, that's your problem. So by process of elimination, B looks like a good candidate. The non-mistaken party was aware of the mistake and did not correct it. So if one party was aware of the mistake, if you remember, we looked at an example where John sold that refrigerator to Lisa. And Lisa's requirement was to operate this fridge in a hot climate. If John knows that this refrigerator should not be sold because it doesn't function well in high temperature, he should have told Lisa. So the non-mistaking party was aware of the mistake and did not correct it. That's a unilateral mistake that make a contract voidable. B is a good answer choice. What should you do now? You want to go to Farhat Lectures, look at additional MCQs that's going to help you understand this concept better. Whether you are studying for your CPA exam, business law classes, invest in yourself, invest in your career. The CPA exam is worth it. Good luck, study hard, and of course, stay safe.